Okay, so I'm going to give an update on what happened this morning. I'm going to start at the end and kind of let you know what was put on the record at the very end. It was put on the record by Rasmussen that Pete is not testifying against other defendants in this trial, and that he is not handing over his works against the other defendants in this trial. There was some confusion. They are requiring that Pete hand over his original discovery. I believe it's so that he cannot release discovery because discovery is still protected. This does not include anything that he works. They did say, in fact, that it is the original discovery, the original thing that the government gave to each of the guys. So it has none of his works, and his lawyer said that he has all the works, and that will not go to the prosecution. So we're going to go right to the beginning. They ask a lot of questions to Pete, making sure that he wasn't coerced into this. The terms are non-binding. He's waiving his trial rights. He cannot withdraw his plea if the if the judge doesn't go with the suggestions. And she did go in length talking about how it's not binding. She does not have to go with the suggestions. His sentencing guidelines were a base level of 10 plus 6 levels because of the, what did it say? Something about the victims, and plus 5 levels for something else, and goes to 21, minus 2 for accepting the plea, and a 4-level reduction for timely resolution, leaving it with 15. He said they don't know about the criminal history, so it could go up after pretrial does its pretrial sentencing, whatever. They agreed to recommend time served. Once again, this is a recommendation. Let's see. Sorry, I'm trying to hold this and do it at the same time. They're not asking for any forfeiture. They are both agreeing that the defendant could be released pre-trial. He is not allowed to be speaking with any defendants or witnesses, anything like that. They talked about the fact that he's taking a felony. The max sentence is 6 years with $250,000 restitution. They said they're not asking for restitution, but once again, the judge is not binded by any of this. They did say $100 per count will be due at the time of sentencing. And she is not required, once again, she's not required to go with the suggestions. Parole has been abolished in the federal system, so they are, there's the thing called supervised release, not to exceed 3 years. That's after his time, so he could be given more time, and then 3 years supervised release. Then she goes in extensively to talk about supervised release, saying that if you do great in your first year, but then you mess up, you could be then put back into prison for the whole 3 years, and that your prison time could be longer than your actual, mandatory time, or the top level of time. So they're saying here that, 6 years is the maximum, but if you're given 6 years and then 3 years pre-trial or supervised release, and then you mess up at those supervised release, you can then be additionally given 3 years because you messed up on your release and actually serve 9 years. So then we go into the guilty plea facts. On March 28th, the BLM feds were exacting a court order. He knew Cliven and Sons planned to impede or interfere with that court order. Santilli used force to impede by using his car to block the convoy path. That he was ordered to move his vehicle and did not until, and then in the courtroom they actually said until a BLM officer forcefully started to move the car with his car. That was then said, no, that wasn't part of it. They took that part out. So it was reread without the vehicle. He did not move it until asked several times, and then he moved his vehicle. By using force to block the convoy, he allowed other defendants to surround the convoy and threaten federal officers with force. And then the court accepted his guilty plea. Then they talk about the pre-sentence report and the fact that he has to really pay attention to that because it's not just used for the sentencing. IRS can also use it. Homeland Security can also use it. His sentencing is scheduled for Thursday, January 11th, 2018 at 8 a.m. Something about no forfeiture. They're not asking for forfeiture. Something about a money order, but that was figured out, or they agreed to something. They talked about all of his motions that they're taking back. Most of them were joinders, except for 2552. Exclude references to Oregon trial. So it looks like that's the only one that somebody has to file again if they want that put in for them as well. They motioned for a release and would like to be returned to Cincinnati. The release conditions, and they pretty much took the Oregon release conditions and read that. So he has to go through a mental health evaluation. Travel will be limited to the District of Nevada and the Southern District of Ohio. No weapons in the house. Submit to search. Then they started to do monitoring, and he was going to be on a monitoring device. He was going to have to pay for that. They wouldn't be allowed to do anything. He has to get a job right away, a full-time job. He talked about how he's a disabled veteran, and that might be a difficulty. They have to talk about that with pretrial release. He's not committed a new crime, but they will not stop him from broadcasting anything. His lawyer then gets up and says, Mr. Santilli will not broadcast anything to do with the Bundy trials, or this trial, he said, or the Patriot community. So this is I believe, part of the pretrial stipulations. But his lawyer got up and talked about that. Then let's see. If he violates anything, the pretrial services will alert the law enforcement officers. Then, once again, I'm going to end with what they ended with in the courtroom. I started with this. Mr. Santilli is not testifying and will not turn over work products, only the raw discovery. Once again, that is because the raw discovery is protected. And it's only what was given to him in the beginning, the raw product, nothing that's been worked on. He has only had one subpoena entered for Marty Martinez, so one of the other lawyers might possibly have to do that. He will not directly or indirectly break the protective order to not release the information. That's the discovery. And that's all I have. We're going back inside for the other hearing, where we will find out if Eric's lawyer is allowed to quit. All right, we're giving it just a second. We will talk about the first part of the day. Sorry, I am holding my own phone, so it's a little funky today, and I don't have a stand, but we're making it work. So we started with U.S. versus Ryan Bundy. This was a motion because of the strip searches. And so he is not in the courtroom, but he is on the phone. He talks about the fact that Miss Dow's was there as his co-counsel, but he has okay, we had to move. So he objects and he wants to put something on the record. She says, this is a hearing that I scheduled for you. Your wife had a document that she filed for the last time when he wasn't there, and this hearing is to give you an opportunity to talk about this. He begins to try to read something, and he starts going into it, and she begins stopping him and telling him, that's not what we're here for. Right now we're here to talk about the strip searches. I'm trying to give you the opportunity. He's trying to read again. He won't stop trying to read, and she keeps trying to interrupt. Ryan Bundy says, I do not contempt. And then right then she, Okay, we're back again. So I'm going to make this short because obviously I don't have good service here. She revokes his right to self-cancel. Ms. Dow's, are you ready to proceed? She says, well, she hasn't been able to view any of the discovery. She's not able to proceed. The judge and Ryan Bundy continues talking through all of this. And the judge is trying to talk over him. Ms. Dow's is something about she's pregnant. She's talking about needs time, and she still wants off this case. Their relationship is not good. So the judge appoints him Tom Erickson as a new lawyer. Tom Erickson is not ready to start on Tuesday. The judge then Okay, so the judge then severs Ryan Bundy and puts him with Tier 2. The government then objects, and they talk about possibly pushing the trial out a few weeks, and then he would be able to... All right, we'll give a few minutes for everyone to get on here. We had a long day at court. It was supposed to be a very short day, but it ended up being a full day, so lots of things happened. So at lunch, we had heard Ryan Bundy... got a new lawyer, Tom Erickson, and that it was possible he was going to be severed from this tier and go to Tier 2. But then they decided at the end that they would wait to see if there was a continuance, because if there was a continuance, he would possibly be able to stay with this tier. The government does not want him to go with Tier 2. They said that their case, he is a leader and they need him in Tier 1. So then we go back. Ammon is not present, but he is on the phone, and Dan and Morgan Philpott are in the courtroom. The reason for Ammon not being in attendance talks about the employees will not transport. This is good news. He's talking about the strip searches. He goes in to say that, you know, he's in solitary confinement. They put him in naked. Then they give him clothes, and then they come to him and they say, we want you to strip out to get out of solitary confinement, but he was put in there naked, and then they gave him the clothes. So he's saying that, you know, it's not about safety here. It's about submitting, and that there's issues. They get CCA on the phone. They get the assistant warden on the phone. There's some arguments back and forth. The judge is saying, well, I can make an order. Is there an order? Is there something we can do to get these defendants to court? It comes down to they are going to move them to Henderson, where their strips are like once a day when they come back, not before they leave. They don't have to strip out before they go to a video call or see their lawyers and things like that. So it sounds like moving them to Henderson is going to fix a lot of things. They are going to approve that they stay in their undergarments, and they're allowed to strip down to their undergarments, but then they're allowed to keep their undergarments on, and they will be wanded and patted down versus the strip search when they move from CCA to Henderson. And then Henderson should have different things. They didn't discuss exactly how they will do that differently at Henderson, because Henderson wasn't represented, but it looks like they're on a way to making sure that Ammon and Ryan are in court. Let's see. After lunch, there's a gentleman on the phone from Reno. They have the motions to continue. They talk about how first there's Ryan Payne's motion that wants 30 days. Ammon and Philpott request to go moving to Reno or going out to 90 days. So they're talking about either they're going to move this trial to Reno, and if they do that, they're going to have to do a different jury pool. They're going to have to push it back anyways. Or they're going to push it back here 30 days and see where we're at. Then that she wants everyone to go through and give how they feel about it. We have lots of arguments between Ryan Payne and Ryan Payne's attorney. Ryan Payne's attorney says, and I quote, they've always pushed for a speedy trial. He understands the necessity for the men that are held in pretrial. I mean, he goes on forever. But he agrees that 30 days might not be enough. He has said he is representing Ryan Payne, and regardless of what Ryan Payne wants, there are certain reasons where he needs to make the final decision. And since if they go with Ryan Payne's decision, he is not giving counsel, and he's saying he understands Ryan Payne, but Ryan Payne doesn't understand his need to be able to represent him. The judge decides that she's going to take both of their things into account, and that one doesn't have to be over the other, and she can decide on both of them. Norwood again says, I am the lawyer and I make the decision. Philpott goes in and says, right now we're starting an unfair precedent. This is unfair to pit the defendants against their lawyers. He's saying, of course they all want to start the trial on the 10th. These guys are detained. So to ask people that are detained, do you want to wait 30 days to try to get a fair trial, or do you want to go? All of the defendants that are detained are going to say we want to go right away. Ammon says there's a prejudice that's not being considered, and that's the prejudice that the government was pointing weapons at a crowd of people, and there's a prejudice against the government. I actually saw Ahmed giggle and laugh at that. They all thought that was quite funny that he was arguing their side, but I don't think they take that seriously, and I believe that there is some type of prejudice that will go to that, or at least that's something people will see. Whipple goes in and his position is neutral. Marchese is a no position, no objection to the continuance. Leventhal wants to move to Reno. He also wants to state that he set his schedule saying that they would start October 10th and has planned a vacation for December 24th to January 9th. She pretty much ignored this completely. And this may cause issues because they're not going to push it back so much, or that we know right now. And he wants trial to be pushed out 90 days or longer, or to be moved to Reno. The government echoes the position that they have a number of speedy trial rights. Here we go again, where the government's going to argue speedy trial rights when it goes to them. And it brings up the Tier 2 and that the events are unrelated. And they oppose a lengthy continuance and no later than October 30th. Tom Eckerson, this is the new Ryan Bundy attorney, he does not see any way that he can be ready in 20 days to fight for him. He can be... He said something about he can be ready to get him ready. She still holds out, or can you be ready to get Ryan Bundy ready? Because she still holds hope that if he is able to pass another Ferretta canvas, he may be able to represent himself again. But he needs to show that he has unadopted this belief of nonsensical things that he's saying, that he to be able to continue representing himself. She felt someone was filling his head with all of this nonsensical motions to fill and words to say forth that are magical, that is gonna get him off. Pretty much as soon as he starts that, she even tells Eckerson, go and look at the motions he's filed, and you'll see what I'm talking about. Then the judge says we could just go with the 10th and try to pick a jury and see what happens. See if we have an issue or we don't have an issue. There's some questions on the questionnaire that didn't get answered because they weren't coded correctly, so the answers didn't get saved. So there's a issue on that. They're talking about making the jurors answer them when they come in. Then there was talk about adding them or sending them back out if there's a continuance. The judge rules. She's not going to move the trial to Reno. The shooter had a home in Reno. He met his girlfriend in Reno, frequented many casinos in Reno, so she doesn't see that. She is willing to continue it at least 30 days. She's going to the calendar call on October 24th at 9 a.m. At this time, they will decide if the 30 days was adequate enough or not, and if there is a prejudice or not. Then Philpott gets up to say that he needs to move that we use strong measures because he believes there's a perceived prejudice or a presumed prejudice, and that they need to use strong measures to make sure that that doesn't come in and doesn't affect. Ryan Bundy is going to stay with this tier at this time. And then when his new counsel is able to talk to him, then he will be able to decide whether he wants to sever and go to tier 2 or he wants to stay with us. So it sounds like they're not really going to listen to what the prosecution wants. If Ryan wants to sever, it's possible. She also stated that she wants a competence hearing. She does not think that it's something that needs to have medicine to fix, but she definitely feels he is under the persuasion of someone who's feeding him bad counsel. Then Ryan Bundy's new lawyer decides he's going to withdraw. He says he was reading things. He's got another case that is going in October. She's kind of like, well, we told you the dates. If we started on the 10th, this would go into November regardless. So there was arguing back and forth, and he will stay on as counsel until they can find another counsel. So now Ryan has gone to one counsel who's going to go to yet another counsel. CJA will find someone else that can take on this trial. And then, so he's up in the air, but it sounds like she's willing to let him represent himself still, as long as he comes to the court with her ideas, not filing what she thinks is adequate motions and adequate speech in the trial. So we end today with October 24th, Tuesday at 9 a.m. we're going to have a calendar call. And then at that point, they're going to decide, is there, famous people coming to town, doing vigils, doing benefit concerts, if it's calmed down, if they think they're going to be able to. They may go into jury selection to see, are they going to be able to. They're also talking that the jury, they push this around so much, and these the juries have had these sheets, they might end up having to let this whole jury go, put reissue papers out, because these when you get a jury summons, you're only on from this time to this time. And we're running out of that time. And she also showed a giant paper of numbers, they don't show names, a bunch of numbers of people who are already requesting to be released from this because it's gone on for so long, something's come up. Maybe they've had people in this shooting that they now need times out. So the new trial date, tentatively, is Monday, October 30th at 8:30 in the morning. That is if everything goes well on October 24th at the calendar call. So today was a huge day. I know that I went through that quite quickly, but it didn't go quickly in the courtroom. And, there's some really good things. I like the fact that Ryan Bundy wasn't immediately moved into Tier 2. That I felt was good. I like the fact that he's supposedly going to possibly be able to represent himself again. She said that to the lawyer. The lawyer's like, there's no way I can be ready in 30 days. She said, well, Ryan Bundy has been prepared to represent himself, so you can get in there and talk some sense, basically, is without her words, talk some sense into him. He may be able to pass this for and continue representing himself. Also, in the middle of the day when they went to decide if they were going to let Marchese go, he was trying to withdraw himself. He decided to withdraw his motion to withdraw, and he is going to continue with us. So that was another turn and twist. Eric said when we got here, he must have forgotten how much he loved us, and we are going to continue on. So we've had a lot of roller coaster moments today. Lots of things have happened inside. I'm sure there's a lot of people that are upset about things. Obviously, with everything being moved back, there's lots of people who have made schedules and days and hotels and everything to come down here that are not all going to have to be changed. And let me warn you all that it may have to be changed again. So everything's not set in stone. We are coming back on the 24th to see if that was long enough, because she didn't say that she wasn't going to continue anymore, and she didn't say that it was for sure going on October 30th. She did say she was not going to move it to Reno. It wasn't far enough. She didn't believe that that would get them far enough away, and that the shooter was also had ties to Reno. Another thing that they talked about is they talked about the fact that the government may even try to use this event against these guys in trial. And the government says, oh no, that's not true, that's not possible. And I believe it was Ryan Payne said, he's the one saying this. He's saying this government's even trying to use this against us. They're going to bring it up. And so the judge then goes to Myrie and says, well, Myrie, what is this? And Myrie's like laughing it off, like, oh, Ryan Payne says, it's changed things in plea deals already. And of course the government's like, no, that's not true. But I feel like it is true, because plea deals were getting harsher. The second the shooting happened, people who were in negotiations, all of a sudden the deals changed, or the deal's off the table, and we know that for sure for us. So to say that they're not using that against us, I don't know. I don't know if it's not provable or whatever, but we didn't end up going into that. But Myrie definitely laughed it off initially. Then they all had a little meeting of the minds, and they said they did not see any connection between what happened October 1st and what happened in 2014. And they do not expect to be continuing or trying to link these two things. So it's good to have that on the record now to make sure that they're not doing that later. I still think motions in limine need to be put out there. So basically it was a lot of up and down today, and we are sitting here with a new calendar call and a new trial date. They are not going to go ahead with this October 10th. There was issues with the questionnaire went out to the jury pool, so they're going to try to fix that and figure that out. And looks like the group of us are going together. So that's all I've got for everyone today, and share this, and I hope that see you all at trial.